Okay, well, it is 9 o'clock and we've got a good number of people that have joined, so welcome. Again, good morning, good afternoon, good evening. I put a couple of messages in there. The second message in the chat is that the slides and the program will be made available shortly after, probably about a couple of days or so. We'll make it available to everyone that registered. So in case you joined late or you didn't have a chance to watch the full program or wanted to go back and re-review something, it will be available, and don't worry. I oftentimes get a number of folks that will ask me throughout the program about getting the link or the video or slides, what have you. Now, I won't answer this time. I'll just keep going in the presentation, but did put that in the chat so everyone is aware. We will make it available. Okay, well, hey, delighted to be here. Really pleased that everyone has joined for another session of how to avoid big startup mistakes. I will give a quick little overview of our program today, and then we will dive right into it. Next slide, please. So just a quick overview of the agenda. I'll do a quick intro on myself and the firm, talk a little bit about the overall topic today we're going to be discussing, and then dive into a few selected examples where I oftentimes will see key mistakes that are made by startups, and also address some of the ways that those can be avoided. So hopefully what you will all take away from this is recognizing some of the trips, traps, and pitfalls. And in your future dealings or current ventures or future ventures, you will at least recognize those as you see them, and will take action and hopefully not fall prey to any of these mistakes. So the first one we'll talk about is just how to document the deal. I'll give you a couple of examples of where a deal went wrong so you can kind of see the impact of it. And then also some thoughts on how to prevent that from happening. We'll talk a little bit about capitalization, which is a really key issue for startups, where things can go wrong, how to make sure you're keeping on top of the capitalization of the company, and some thoughts and issues to be aware of. Next topic will be corporate hygiene, just making sure that there's good record keeping, good documentation. This can lead to a whole bunch of problems that I'll talk about in a little bit. Preparing for your first deal, what are some of the things you should be thinking about? First deal, what I mean really is sort of a financing. I mean, it can apply to sort of any deal. It could be a joint venture transaction, a partnership transaction, or something like that. But I'll be talking about some of the common things I see when you're preparing for your first financing transaction. And then the last topic will be diligence. We'll talk about some of the important issues that sometimes are messed up or can be problems for startups if they don't pay attention to diligence. I'll open up and leave hopefully about half an hour or so for Q&A. I may take some questions as we're going through the program. I'll try to save a good amount of them for the Q&A session. But if I see something that's relevant and I can talk about it quickly, I'll try to do that. And then I'll give you some examples of common pitfalls that I've seen over the years. So that'll be part of the takeaway as well. I'll run through a bunch of additional examples beyond what I talk about during the presentation. Okay, next slide, please. Great. Well, a little bit about me. So I'm a corporate attorney with Foley Lardner. My practice is primarily working with emerging growth and venture capital companies. I'm doing this for 20 plus years. Really enjoy and am passionate about working with startups, working with investors, seeing the whole sort of range of, very early stage from inception all the way through exit. I work out of our San Francisco office at Foley Lardner, and I've worked with companies that are all over the US as well as coming into the US from other countries. So a fair amount of cross-border work as well. Really enjoy working with entrepreneurs, founders, and investors. It's really a wonderful adventure. And if you've been in it and have done it before, you understand it. If people are usually pretty passionate about their startups, you need that passion because that's the fuel that keeps you going late at night, early in the morning, on the weekends. It's a really tough grind to create a startup and work all the way through everything it takes to a successful exit, whatever that may be, whether it's an IPO, whether it's a sale, what have you. It's no easy feat. So really enjoy the passion, the energy that a lot of the entrepreneurs and founders and the investors too, who are also passionate about the companies they invest in and the industries that they are involved in. So a little bit about me. Let me go to the next slide. We'll talk a little bit about a couple quick quotes. I love quotes. They encapsulate so much more than I could probably say in a few minutes. The first one I put up there is just we're talking about how to avoid big startup mistakes. Mistakes are not bad things. Oftentimes, I mean, they're bad, but they also have incredible learning opportunities. So if you can learn from mistakes of others, then obviously that is a huge help for you, and you can help avoid making some of those mistakes. And then they're a fact of life. You're going to make them. We all make them. It's how you respond to it and keep going that is a measure of success in my mind. Next slide, please. Okay, so let me talk a little bit about Foley and Lardner. I had some slides in one of my other programs, but so we are a large international firm. We have about 25 offices throughout the U.S. and several offices outside the U.S. We are a full-service A to Z firm, soup to nuts. We do everything from corporate, executive comp, employee benefits, tax, IP, so patents, trademark, copyrights, litigation. And then we have a focus on a number of industries that we do a lot of work with, as well as many others. But we do a lot of work with manufacturing, healthcare, energy, and really bring a team approach and a sort of full service approach to a lot of the clients we work with. We work a lot with startups, so we understand the startup space really well. That's primarily where I've been working for over 2 decades. So anyway, a little bit about the firm. So delving into the topic here, one of the first things that is really important, I think, to avoid big startup mistakes is just understanding how to document a deal. And this could apply to anything, whether it's a vendor agreement, a customer agreement, an agreement with your co-founders, whether it's financing. It's really important to understand how do you document a deal. And I'll give you an example here, which was a client that came to me a number of years ago. They had signed a deal with a friend of theirs, and the client that we represented was the tech person. So he had developed some really cool tech that was useful for the videography and photography market, and had created the idea, had the prototype, but needed someone to be able to manufacture it. He had a friend who had a manufacturing company, and they had some discussions, and my guy basically said, great, you be the manufacturer. I've got the technical know-how. Let's team up. I'll give you 50% of the company. They signed a very, very short, badly worded one-page agreement. Basically, the original founder, the one that really had the idea, the technology for the company, gave 50% of the company to his friend, the manufacturing co-founder. And after a few months of trying to manufacture, trying to deliver, trying to create these products that would work according to the specs, the manufacturing friend couldn't do it. They were having problems, delays, cost overruns, the unit wasn't working properly. So the relationship soured, and ultimately the co-founder left. The manufacturing friend left and said, yeah, I'm not interested. I mean, I'll keep doing it, but now you got to pay for the manufacturing costs and my time. And my client was saying, well, wait a minute, I gave you 50% of the company, and that was to cover all of that stuff, so I didn't have to go out of pocket. Otherwise, I would have gone to some other manufacturer. Anyway, long story short, the co-founder manufacturing friend left with 50% of the company and was not participating anymore. So it was a huge issue. And had our client come to us earlier, we could have drafted an agreement to properly document the relationship and build into it provisions that would account for someone wanting to sort of terminate the agreement or leave, or if they couldn't perform and things of that nature. And unfortunately, they didn't. So next slide, please. So basically, the only option he had, because he really wanted to continue on with the company that he created, was to buy his co-founder out. It cost him a pretty penny. We negotiated that buyback of the 50%, and he was able to go on and make a successful company and all that. But it was a very painful lesson, because he gave away a lot of equity very early on without any sort of strings attached, any sort of conditions, and it was a real issue. So key takeaways here are: do your diligence, really understand the relationship you're creating. If you have a co-founder you want to bring in, or whether it's a partner or a joint venture partner, what have you, you really need to do your diligence. Understand the person, understand what they're going to contribute, or the company, and what they're going to bring to the table. Troubleshoot. And what I mean by that is ask the what if questions. And this is where sometimes it's awkward or difficult, especially if it's with a friend or a family member that you're getting involved in a deal with. But it's really important to ask all the what if questions. What if you can't do what you say you're doing? What if you can't do it for this price? What if you can't deliver on time? Those are all important questions that you need to be able to ask, and then work your way back into how to create some sort of document that's going to help govern that relationship, which essentially is what you do when you create a contract. You're trying to create something in writing that will help govern that relationship or govern that transaction. And so understanding not only all of the objectives is critical, but also understanding what can go wrong is going to be really helpful, because then if you think about some of those scenarios, worst case scenarios, you can then try to draft into the agreement ways to minimize or mitigate or hopefully avoid them from happening. So documenting the deal properly is really critical. The resolution in this particular example was a lot more expensive than it would have been had he just gone to a good attorney in the very beginning. Next slide, please. So back to, so how do you document a deal properly? Well, I talked a little bit about that. Some key issues to consider is outline the relationship. I mean, this could be as informal as you sitting down either by yourself with some advisors, friends, lawyer, etc. But outline what that relationship is supposed to look like, or what you want it to look like. Specifically, what are they supposed to be doing? What are you supposed to be doing? How are you guys going to make money? Who's going to control what decisions? All of those sorts of things. Obviously, the parties should be clearly indicated. The key terms, what are the key terms in the relationship that you're trying to document a deal around? What is the ownership going to be, if there is going to be any sort of ownership? And in this case, we're talking about bringing in a co-founder. So obviously ownership is going to be a very important issue to talk about. How much do they get versus how much do you retain? What are they going to be bringing to the table for that percentage that they want to get, et cetera? Are there going to be some sort of conditions on what they're going to be getting so that if they don't perform, the company has the right to reacquire those shares back if they end up leaving before a certain time period, et cetera. And I'll talk more about that as a little bit. Is there a timetable for the obligations of the parties? Confidentiality is important. Any sort of limitation on liability, indemnification, those are all other issues that are important to be thinking about, depending on what relationship it is you're trying to create and document. Okay, so a question really quickly. I'll see if I can cover this. What do you mean by buying out a co-founder? Well, in the example I gave is he had an initial person that created a company and he needed a manufacturing sort of partner. He needed to bring in someone to the company to help him with the manufacturing. So he actually brought in and made his friend a co-founder, meaning they both now were considered to have created the company, co-founded the company. And you want to make sure if you have a co-founder situation, whether it's one co-founder or two co-founders or more, that there's some mechanism in place so that if one or more of the co-founders decides to leave, then the company can repurchase their stock, without having them leave and take the stock with them. That's a big issue because in this example I gave, the person walked away with 50% of the company, which in that case created even more issues because now you have at the ownership level a 50-50 ownership, and if there are decisions that need to be made by the owners and the person that walked away doesn't want to participate, doesn't want to come back for meetings or anything like that, then the company's stuck. They're paralyzed. They can't make a decision at the shareholder level because one person who's there participating may want to do something, the other person's either not responding or just says, no, I don't want to do it. So now how do you act? How do you properly operate the company if you've got the stalemate position? So that's what I mean by buying out a co-founder. I'll come back to the other question about governments a little bit later. Okay, so we talked about ways to document the deal. This can apply to any sort of relationship, but just keep in mind, do your diligence, ask do the troubleshooting, ask the what if questions, understand what everyone's bringing to the table and obligations, parties, terms, things like that. Next slide, please. Okay, so before we jump into sort of what I call cap table chaos, an example I wanted to talk to you about. Another example, which is similar to the one I gave you about documenting your deal. And this really goes to oftentimes when you create a company, if you're allocating shares, whether it's to a co-founder or even if you bring in early employees or advisors, what's really important is if you're giving them equity, to have some sort of mechanism that you can repurchase those shares if they end up leaving, if the relationship doesn't work out and you have to terminate the relationship. With co-founder, the termination of the relationship is a little bit different if they're coming in as a co-founder. But if you bring in, for example, an early employee, consultant, advisor, and it's just not working out and you want to terminate that relationship, if you've given them equity in the company, whether it's stock options or whether it's stock, then you don't want them to walk away with that. And so there is a way that you set up in the agreement a repurchase right. If you give them stock, you restrict it, and it vests over time. And what that means is the company has the right to repurchase that stock up until the point when the repurchase option lapses. And that usually lapses over time. But the very standard time period is 4 years with the 1 year cliff, which means they don't get any, the repurchase right doesn't lapse until after the first year of service, and then it'll lapse as to 25% of the stock. And then the remaining stock, the repurchase option on the restricted stock, will lapse over time over the next 3 years in equal installments. So basically at the end of the 4th year, assuming they're still there and they're still participating and the relationship hasn't been terminated, they will have vested in all of their stock, which means with regard to the stock that they get, the company then no longer has a right to repurchase any unvested shares. You may still negotiate a right to repurchase, but it's a little bit different and a little bit beyond the scope of this discussion. But that's on restricted stock. On options, it works a little bit differently, but same basic concept. When someone is given an option, it will vest over time, same 4 year with the 1 year cliff period. But because an option is a right to purchase stock in the future, they don't get the stock on day one. They get a right to purchase it. So that right vests, and they can't purchase and they can't exercise and purchase the stock until those options have actually vested. So after the first year, they'd have the right to purchase 25% of those options, stock, and then they can purchase every month thereafter once more stock vests. So that's how it works with restricted stocks and options. But that's a really critical component to keep in mind. Okay. Capitalization, another great topic to talk about. So what is capitalization? It's the ownership of the company. Nowadays, with technology being what it is, there are really great programs out there that help you manage your cap table. They're cloud-based, electronic cap table management programs. And you put all the data in there and it'll tell you at a very quick moment's notice who owns what do they own, how many shares, what their percentage ownership is. That's really important to keep an eye on throughout the adventure of being a startup, because it's going to change. There's going to be dilution to the founders as you grant more options or grant more restricted stock to people and you bring them in, as you complete financing rounds and sell stock to investors. All of that's going to impact the ownership. So really important to keep track of it, make sure you've got proper documentation, and that when you make changes to the cap table, increase shares, create new classes of shares, that you do it properly and have the right documentation. So here's an example of where that wasn't done, and big mistake that a startup made. So basically they created a company, they created with a minimal authorized number of shares. And when you form a corporation, you need to indicate how many shares that corporation has authorized that they can go ahead and issue to people, whether it's founders, employees, advisors, consultants, what have you. Think of it as a checkbook. You go and open a bank account, you put $1,000 in, you only have $1,000 to spend. You don't want to spend more than $1,000. So you create the corporation. Let's say you put in this case, they put in a minimal number of shares. They put in 1 million shares, and they forgot that they only had 1 million. But then they went out and hired a whole bunch of people, and they started giving options and restricted stock. And pretty soon they blew past that 1 million shares that they had authorized. So example, analogy, they actually wrote checks for more than $1,000, and now they were bouncing checks because they didn't have more than $1,000 in the bank account. So similar concept when it comes to corporations and authorized shares. You don't want to ever issue more shares than the company has the authorization to issue. So to make matters even worse, they wanted to create even more shares, so they did what's called a forward stock split. So they said, okay, for every 1 share that we have, we're going to multiply that by, I think it was 10,000. So now we're going to create a whole bunch more shares. So we've got more shares to issue. But the problem is they never filed the documents appropriately. And so you have to do that effectively. You need to actually amend your charter, your certificate of incorporation, by filing with the Secretary of State to affect the stock split. They didn't do that, but they thought they had. And so they operated as if now they had a whole bunch more shares. So they kept issuing more and more shares. Anyway, by the time we got them as a client and looked at their books and saw what a horrible mess they were in, we had to go back and basically clean it up. And it was complicated because they'd done these splits a couple of times, and they had a whole bunch of people out there that had a whole bunch of shares that they didn't actually validly have because the company couldn't issue more shares than they had. There's ways of cleaning it up and there's ways of correcting it. It's just, it took a lot more time and a lot more expense than had they just had a good attorney to make sure that everything was being done properly from the get-go. Okay, so a couple of quick questions. Do options dilute over time? Is it better to give early founding members options or RSUs? That's good questions. I mean, good question. Yeah, anytime someone gets, whether it's an option to purchase shares or whether it's restricted stock, yes, over time, that can be diluted in the sense that if you give them 100,000 shares or an option to purchase 100,000 shares today, and if the company has 1 million shares, then they've got 10% of the company, right? Potentially. If it's stock, they've got 10%. If it's options, they have the right to get 10% if they exercise and purchase all 100,000 shares. But let's say in 6 months you go out and raise a round of financing and you sell, 5 million shares, or sorry, not 5 million shares. Let's say you sell of the 1 million, you sell an additional 500,000. So now you've got a total of 1.5 million shares out there. So of course that additional 500,000 shares that you've sold is going to dilute the people that had options or restricted stock early on, because now they're 100,000 shares. Once if they have an option to purchase, once they purchase, or the 100,000 shares that they have now is not going to equate 10% because you've got the count for the additional 500,000 that the company sold. So yes, they do get diluted over time. Something to be aware of, something to be thinking about as you're looking at and managing your cap table. And it's especially important when you go to raise your first financing, because you as a co-founder or founder want to make sure you understand how you're going to be diluted if you go and sell a bunch of more stock to investors. I do a couple of other programs. There's one on how to prepare for venture capital financing. That one I go into a lot more detail about the capitalization with regard to financings and dilution and things like that. So I'll probably be doing another one next month. And you may also be able to find some online of ones I've done before, or reach out to me and I can send you the link to those. Okay, so short story is they just didn't do the documentation properly. The cap table was all messed up and then we had to come and clean it up. Next slide, please. So one of the other issues that happened was because of these problems, we needed to then go out to the stockholders and tell them what had happened, right? Because they all thought they had gotten more stock that they didn't actually have validly. So we had to inform them about this. We had to then, inform them about what the fix is going to be, and then prepare the documents to go and have everything fixed. So the key takeaways: capitalization structure and changes, they really require proper planning. If you're going to be doing any sort of changes to your capitalization, make sure you talk to an experienced attorney to get good advice on how to go forward with that process. You you will need board consent. You typically need stockholder consent. There may be other consents and approvals you need if you've got other agreements out there that give certain people rights to consent or approve transactions that might involve some sort of capitalization change or structural change. The documentation needs to be prepared properly, and then whether there needs to be a filing with the Secretary of State, and if you're issuing more shares, then you need to be aware of the securities exemptions. The filings need to be made. So there's a lot that goes into that. And the best way to avoid the mistakes that I've seen some startups make is get a good attorney on your side to walk you through that whole process. Some of the stuff about the securities regulations and the filings, we do that on a regular basis, so we can kind of guide you through the process and make sure those filings are prepared and filed properly, so you don't have any of those issues. Next slide, please. Oh, okay. So one question: what's a cap table? Good question. So capitalization table, or cap table, is essentially a table that is created to show the ownership of the company. It will show who the stockholders are, the number of shares they own, the percentage ownership that they have in the company. It oftentimes will also include the people that own options. And even though, as I mentioned earlier, an option doesn't give them stock right away, it gives them a right to purchase stock in the future. You still want to put them on what's called the cap table, because you want to know if these people were to exercise and purchase stock, what would their ownership be at that point? Understanding that's going to be important, because that all goes to, especially as a founder, your ownership of the company. So again, the example I gave earlier, if you've given out 100,000 shares, or if you've granted 100,000 options, and you have 1,000,000 shares in the company, that's great. Right now, you own 100% of the company. But once those people exercise those options and purchase the 100,000 shares, now they're going to own 10%, and or roughly about that when you do dilution. So you're not going to own 100% anymore. Your percentage is going to be diluted down. So accounting for all that in a spreadsheet, which is the traditional way it was kept, it was usually kept on Excel, and many companies still use an Excel. And if you're really small, 1 or 2 founders, that's fine, as long as you get guidance on how to prepare and manage it. But as I mentioned earlier, there's some great programs out there that allow you to help organize and maintain that really easily. Another question, whether we can review offers sent out to founders. Yes. I'm not going to address any specific examples, and I should have mentioned at the very beginning of the presentation. I usually do, but forgot about it today. What I'm talking about today is all educational. It's all very high level. I'm not going to be addressing any specific fact patterns you have with regard to your particular issues. So none of what I'm saying should be considered legal advice. It's more educational and it's very high level, but I'm happy to talk with you offline separately. Just email me. My contact information will be at the end of the program, so you'll be able to reach out to me. So getting back to capitalization, think about it this way. You're trying to strike the right balance between allocating equity, especially when you're starting early stage. You're talking about, maybe it's 2 founders, 3 founders. How do you allocate equity amongst the different founders? How do you allocate equity to early employees, early advisors, early consultants that are going to be joining your company? Really important to be thinking about that and thinking about not only currently what that should look like, but ultimately, in the future, and in 6 months, a year, 5 years, and planning for it. So I oftentimes say, think about where you're going to be in a year, 5 years, including thinking about, you're going to have to go out and raise financing. So you're going to have to sell a percentage of the company to raise that financing. How much would you typically sell, or might you anticipate selling? And then work backwards to, okay, now today, if I know that ultimately I'm going to be doing X, Y, and Z and raising capital and selling, maybe up to 30, 40, whatever percent of the company, starting today, then I want to be really careful with allocating equity to early employees, early advisors, early consultants. One big startup mistake I've seen is company gets founded, they need to bring in advisors and consultants to help with certain things. So they bring in an advisor and they basically give them 10% or 15% and 20% of the company. That's a huge amount to give to an advisor, especially if that advisor hasn't proven themselves. So it's a very different scenario than allocating equity amongst founders, because typically founders are bringing something to the table right then and there. So not always, but oftentimes. So for example, you've got one of the co-founders that's the technology guru. He or she has created the technology. They've written the code. They've got a prototype. They've got the technology and the experience to be able to build it. You might have someone else who's got the finance experience and finance that they can bring, the finances to bring to the company, so they can actually contribute capital. And maybe you've got a third person that's got all the networks and can reach out and talk to investors and get meetings and things like that. So all of those could be provided, day one. Whereas an advisor coming in, you don't know, are they going to show up for meetings? Are they going to contribute? Do they have really valuable experience? You may not know them that well. So you want to be really careful. And typically grants made to early advisors and employees and consultants are usually pretty small. You typically don't give out a lot. I always tell this to clients who are asking me, well, how do I allocate to early employees and advisors? And I always say, look, you can always give someone more later on. Always. That's the company's prerogative. So why not start smaller, let the relationship grow, make sure the relationship is what you want it to be, and that they can actually do what they tell you they can do. I gave an example early on where someone said they can manufacture this product, and it's going to be great, and they can deliver, and then they just couldn't. So you want to make sure you avoid that mistake about giving someone a bunch of equity, options, stock, wherever it is, and then them not being able to deliver. And now you've got the issue of, okay, how do I get it back? Well, if you do the documentation properly, there's ways of getting it back. But I would go one step further and say, don't give them all of that, piecemeal it out or make it installments, or just start small and then grant more stock later on. And there are ways of kind of getting a sense of what's market out there, what's typical, what's not typical. So it mentioned thinking backwards about planning. So think about ownership. think about control, think about economics. I mean, ultimately, the sort of the two main drivers really is control and economics. When you talk about startups and you talk about what's important to founders, but also to investors, it's control and economics, right? I mean, how much control is someone going to have? If you're the founder and you've created a company, how much control do you want to have? Ultimately, at the beginning, you want to have as much control as you possibly can. It's your company, you created it, you want to make sure you make the decisions that you think are the best to grow and scale and have a successful venture. You know, similarly from the investor standpoint, they want to have some control so that they can make sure they're protecting their investment in the company. The other aspect of that is the economics. So important to investors, obviously, they want to make a return on their investment. Important to founders because ultimately you want to have some big payday when the company either goes public or there's an exit and you sell the company. You want to make sure all that incredible work you put into it, the weekends, the late nights, the mornings, pays off. So you want there to be some sort of payout at the end if the company is successful. So the economics are going to be important too. So making sure you're keeping your eye on both of those is going to be really important. And then plan for dilution, as I mentioned. Every time you go out and issue more stock or issue more options, it's going to dilute you as a founder. So you just want to make sure you're keeping track of that. And then the other important piece to this is you need to incentivize people, right? So people are going to come work for you, advisors, consultants, employees. They also are going to want some sort of skin in the game. They're going to want to be able to know that, hey, I'm going to be putting in a lot of work. I'm going to be contributing. I want to make sure I can get some sort of return on my investment as well. And so oftentimes a good way to incentivize them is to give them some skin in the game. You give them some equity, you give them an option. Again, depending on what they're doing and how they're coming in, generally speaking, it's fairly low for early employees and consultants and advisors. But it's still important because now they've got some stake in the game too. Quick question here. In your experience, do most established angels and VCs typically require a 401 evaluation from a third-party cap table evaluation company before investing? Great question. I do cover that a little bit more in other program, but really quickly here is 409 refers to section in the IRS code. If you're going to be issuing granting options, you typically need to grant them at fair market value. And so if you're an early stage startup, what the hell is the fair market value of this stock that I'm going to be giving options for? I have no clue. We don't have any revenue. We don't have really much in the way of operations yet. It's very early stage. How do I possibly come up with a fair market value for the options I want to grant to these folks? Well, you can go out and hire an independent third-party valuation firm that does that. And there are a whole bunch of them, including some that provide the cap table management solution I was mentioning. Part is one of those companies. There's a bunch of others, but they will provide that valuation for you, and they'll come up with a number. They'll come up with a price per share that they consider as the fair market value, and that's a good thing to have if you're granting options. You should have that, because then if the IRS ever comes knocking on your door saying, "Look, we think you didn't price these appropriately. You either priced them way under what they're really worth, or maybe you overpriced them," but there could be some tax consequences. And so if you have done your diligence and you went out and got a 409 evaluation and then granted options, if the IRS ever comes knocking on your door, you've got the valuation to come out and say, look, I went to a third party professional advisors, this is what they came up with, and that's considered sort of a safe harbor. You don't have to have one, but it's certainly recommended when you're doing options. Investors it depends on where they're coming into the picture. If they're coming in very, very early stage, there are no revenues, there are no assets yet, or very minimal assets, it's easier for the board to come up and determine the fair market value as being fairly nominal, because there's really nothing there. A little bit more defensible than if you're much later stage and you just come up with a value you think is a good value without doing the research and getting evaluation. So it really depends. Some investors aren't going to require it, with the caveat that if you are granting options, you really should have a 409. Do you have to have one? No. Should you have one? Yes. And investors will look at that. And if you haven't gotten a 409, but you've gone out and issued a whole bunch of options, that can be a little bit of a red flag. They may ask about that, and they will need to get comfortable that you've actually issued a fair market value, because if you haven't, there's some tax consequences. So hopefully that gives you a little bit of an answer to your question there. Okay, one other question, and then I'll move on. Is it legal to hire someone but only give them stock options or let them purchase stocks and not pay them cash? That's a fantastic question that we oftentimes talk to clients about. So the long and short of it is, and I'm going to talk generally about California because that's where I'm located and licensed. Different states have different approaches, but you think of it as there are federal employment laws and there are state employment laws. And if you are a founder and you have a certain ownership percentage, I think it's 20% or so, on the federal level, there is an exemption. So you don't necessarily have to pay yourself the salary because you're the founder, you created the company, you own a significant portion of it. That's not the case in California. California takes a much more stricter approach and says, look, if you're doing anything that's considered working for the company as an employee, then you need to be paying yourself something, whether it's minimum hourly wage or some minimum salary requirements. But the problem is you're a startup, so how can you afford that? So, our typical response to those scenarios as lawyers is, you need to comply with the law, and so this is what the law says. The practical impact of what I see on a regular basis from a lot of startups that are out there operating is that they don't have the money, so they can't pay. So they end up waiting until they have enough money to be able to pay people. It's risky. It's obviously not compliant with California law. It's what some startups do. So if you can avoid, you don't want to do that, of course, if you can avoid it. But that's typically what I see. So answering the question though, if you're talking about consultants, yes, you can give consultants, stock options or stock, and that can be consideration, payment for the consulting services. That's an easier scenario. If you've got employees and you're just paying them stock, you're under the same scenario I just mentioned, which in California, you need to pay either some minimum salary or minimum wage. You can give them equity as well, but that doesn't satisfy the strict legal, labor and employment conditions. Okay, so moving along, I want to make sure I get through the program and have enough time for Q&A. So we talked about capitalization, talked about dilution, incentivizing your team, proper documentation. I talked a little bit about the vesting and repurchase rights. So making sure you've got those types of provisions in your agreements, including for founders too. So it's important for founders. You don't have to do this for the founders, but oftentimes the investors are going to require it. So you might as well think about it as you're starting a company and going to be issuing shares to the founders, to build into it the same concept of vesting. So that if you've got co-founders, one of them ends up leaving, you've got the company has the right to repurchase the stock, as I mentioned earlier. If you're a single founder, there's nobody else to maybe a co-founder, decision is sort of more of a business decision. Do you wait? Maybe have all the shares fully vested now, don't have any of those restrictions. So obviously you've got more control, back to sort of the control versus economics feature I was mentioning. And then wait and see. You might go into a financing with an investor that doesn't really care. I would say most investors do care. So what they might do is they may come back and say, look, it's great, John, that you set up your company with no restrictions on your stock as the founder. We're not going to invest unless we know you're in it for the long haul. We want to at least vest some of your stock, subject some of your stock to vesting. So we're going to have you amend your agreement, your stock issuance agreement, and build into it some vesting going forward. Does it have to be 100% if you've already worked at the company for a couple of years? Probably not. You can probably negotiate that and maybe have some lesser percentage subject to vesting, but it's something you can anticipate. Okay, so last question, and then we move on to the next topic. For cap table assistance, do entrepreneurs normally use a legal firm or an accounting finance firm or both? For cap table management, so a couple of thoughts. The cap table management programs that are out there, they're third-party companies. That's all they do. Card is one. Estrella is another one. There's a whole bunch of them. They are not accounting firms. They're not law firms. They are strictly a provider of a service that allows you to upload data, manages the cap table. I mean, they've done it really well. So they know all the laws that apply, and they've built it in. So when you go into upload, you can issue certificates, you can make option grants, all from the program electronically. It's really, if you haven't used it before, go check out some demos. It's really saves a lot of time, effort, and burden on the company to do that. But usually, if you're using it properly, what you do is you get your lawyer involved and give them access. So the lawyer and or the paralegal, oftentimes the paralegal of the firm, will then work with you to help make sure that everything's uploaded properly, that the right documentation is being sent out. But it makes it a lot easier. Accounting firms typically do not do capitalization issue. It's not really an accounting feature or function. It's more of a legal issue. It's the issuance of shares. It's the granting of options. Those come with a lot of security law issues and things like that you need to be aware of. There are tax issues related, so accounting firms can be helpful if there's particular tax issues. But for the actual management of it, issuances of stock and granting of options, it's usually either done by one of these programs, company does it itself, but in collaboration with your legal advisors. Next slide, please. Okay, next topic, which is super important topic. Probably of all the different topics I'm covering today, this is the one that oftentimes is overlooked the most. It's good corporate hygiene, good corporate housekeeping, good corporate documentation, use whichever of those you want. But essentially, it's having good organized documents and having a process and sort of building a habit of having good documentation for your company. It's really important. So going back to what I mentioned a little bit earlier on about how important proper documentation is, going forward after a few months or a few years of having set up your company, now you've got a whole bunch of documents out there, you'll see very quickly the importance of good corporate hygiene, because if you've documented everything properly from the get-go, and then you've found a good way to organize all those documents, you basically established a good pattern or practice for corporate hygiene. Because you don't want to have scenarios where you're missing documents, or you had an important document that wasn't signed and you forgot to get the signature, and now there's an issue, and now you got to go back to that person to get their signature, and that's assuming they will sign it at this point in time. You don't have documents that are dated, so you don't know what date particular action was decided or approved, or when the contract started, because you don't know what date it was signed. I mean, that's just a couple of numerous examples where bad corporate hygiene can create a whole bunch of problems. So a couple of examples here. With a corporation, if you're not familiar, corporations have sort of a three-tier system on how the corporation is sort of managed or operated, if you will. At the very highest level are the shareholders, who are the owners of the corporation. They typically don't get involved they definitely don't get involved in day-to-day stuff, or even sort of more managerial or management-related stuff. They're there as the owners. So there are certain decisions that typically the owners will have to make. So for example, if you're going to sell the company, obviously huge impact to the ownership of the various stockholders. So they're going to want to know, and they're going to want to approve a sale of the company. So very, very significant decisions like that. If you've created the company or gone through some financing, you will also most likely have some provisions in your charter, your certificate of incorporation, or maybe some other documents that you have in place with the investors, where you will need to go back out to those investors, those stockholders that have invested in your company, and get their approval for certain actions. And maybe taking out a certain loan above a certain limit, entering into certain types of contracts, selling the company, all sorts of things that are important to the investors, the stockholders, because it may, one, impact their investment in the company, or two, it gives them some sort of control, back to this control versus economic issue, over their investment, to give them a way to help protect their investment. So think of it this way: if you put $1 million into a startup and you wanted to make sure you're doing what you can to protect your investment, you're going to want to have some sort of say-so on what the company does. May not be at the minutia or the day-to-day or even month-to-month level, but there are going to be some things you absolutely want to have a say-so. One example, which is kind of maybe an extreme example, but I think this will illustrate it pretty well, is, so you write a check for $1 million, it goes into a startup, and then the CEO of the startup says, hey, you know what, we're doing pretty good. I want to take $500,000 of your money, investor, and I'm going to go put it in my brother's company because he's starting up a company. And yeah, it's going to get to a point pretty quickly where maybe we'll be able to have a contract with my brother's company to buy some products or services. And you're going to go, whoa, no, you're not taking my money that I put into your company to help grow it and build it, just to take it and go put it in some other company that I know nothing about, and I may not want to invest in at all. That's a good example of having some sort of control at the shareholder level. The next tier down are the directors, and they sort of oversee the management of the company. So they oversee the CEO, CFO, CTO, et cetera, and make sure that they, on a more granular level or macular level, if you will, are overseeing the management of the company. So the officers, CEO, CTO, CFO, what have you, they typically answer to the board. And the board will make certain decisions, granting stock, granting options, entering into certain transactions, things like that. And then the third tier below that, the ones that handle the day-to-day are the officers, the CEO, CTO, CFO, secretary, et cetera. So you want to make sure that you've got the proper actions or proper documentation. So certain actions need to be made by the board. So for example, if the company is going to issue stock or grant options, then the board actually has to approve the granting of an option. So you want to make sure that that's there. You don't miss that. So down the road, you didn't get board approval, you issued a bunch of options, and now you've got an issue because you've got a potentially invalid action. You've gone out and done something without proper authority. Same thing goes with the shareholders. If you enter into some sort of transaction where you need to get the stockholders' approval and you don't get it, that can lead to a whole host of issues. Worst case scenarios, now you've potentially breached fiduciary duties, you've engaged in an action without getting their consent. They may have some sort of right to sue or bring a claim against the company, against the directors for not properly managing the company, overseeing the company, and the company entering into a transaction that they didn't approve of. So good example there of good corporate hygiene, good documentation, making sure it's done properly. Next slide, please. So a few steps for the unwary, missteps for the unwary. As I mentioned, defective corporate actions, defective stockholder actions. We talked a little bit about 498 issues, and so it was a good question when it was asked, because now you see the impact of it. There was a M&A transaction I worked on a number of years ago where the company had been around for a long time and had a whole bunch of employees and had issued a whole bunch of options, but they didn't issue them at the right price. So they didn't go out and get a 498. They didn't issue or grant the options at the fair market value. They just came up with the price on their own, and unfortunately, it wasn't the right price. It wasn't a good fair market value pricing. So now we're at sort of the exit, right? The company's going to be sold. It was a really good deal for the company. It was a lot of money. On the diligence that the investor was doing, the buyer was doing, they surfaced this issue. But wait a minute, you've got these different prices. Where's the 498? How did you arrive at the fair market value? And the company didn't have a good answer. So ultimately, what happened was they had to go out and figure out what the fair market value was. There was a discrepancy. They had granted options below the fair market value. And so that was going to create a tax consequence. So the company had to come up with that additional amount of what the tax was going to be for the people that received the options. And they had to basically gross up the amount that those people were going to get from the sale to cover their taxes, because ultimately it was the company's screw up. And so that's one good example of not having gotten a 498, but having granted a whole bunch of options without proper pricing and not the fair market value. Come years later, when there was a sale, this became a big issue because the actual amount they had to pay to cover that tax issue, it was in the millions. It was a couple $1 million. So it was a huge amount. Anyway, so lesson learned was do it right from the get-go. Okay, next slide, please. Contract mismanagement, another one that I see oftentimes. I touched a little bit about this, talking about undocumented or unsigned documents, undated documents. It's all going to be really important because when you get to your first financing, typically with a sophisticated investor, oftentimes at your first price equity round where you might have a VC or a very sophisticated angel come in, they're going to do their diligence and they're going to look at all your documents. You're going to set up a data room. They're going to go through all your documents. They're going to look at your board actions, your shareholder actions, all the other things that the company's done. And they're looking for red flags. They're looking for scenarios where you haven't done things properly that could cause potential problems for the company, i.e. put their investment dollars at risk. And that's not what they want. They don't want to have some of the money that they invest in the company go to clean up some problem because you didn't get the right valuation or you didn't have the documentation done properly. Now you've got a potential claim and there's going to be lots and lots of dollars spent trying to resolve that claim. So find a way now, if you're early on in your company or if you're thinking about setting up a company, and it's never too late, even if you've been around for a while, is get a good system of managing your contracts. And what I oftentimes tell clients is we're going through the process on the diligence deal is find a way to save the documents so it's easy. When you look at the file name in the computer, you know what it is or you have a good sense of what it is. I can't tell you how many times I've been on a deal we're doing diligence, and they sent us a bunch of documents, and I can't tell from the document what it is. Is it an employment agreement? Is it a purchase agreement? Is it an invoice? Because they didn't use any sort of rhyme and reason. So in one case, it'll say stock purchase agreement. In another case, it just says agreement. We can help, we oftentimes help our clients because we'll give them sort of a standardized way to save documents. And that way, when they're saving it that way, once you see 100 documents in a list and an index, you can kind of go down the list and say, okay, these are the stock purchase agreements, these are the board consents, these are the stockholder consents, and then you can kind of go through those and figure out what you need to look at. It makes it a lot easier and more efficient. Making sure you're keeping track of agreements. If it's a really important agreement, know what you need to know about that agreement. In other words, if there's an agreement, I'll give you a good example. So once you get a little further along, if you end up taking out any debt, you go get a bank loan, venture loan, there's going to be certain covenants in that agreement you're going to have to comply with. And you need to make sure you're keeping aware of those, because oftentimes there can be approvals you need from the bank. So if you want to go out and create a subsidiary, if you want to transfer money from one entity to the subsidiary, if you want to go and issue more shares, you may need to go and get the bank's approval. You may need to get stockholder approval too. That's usually in the charter and other documents. But this is an example of people go get a loan, company gets a loan, and they forget about the loan agreement, but it's got all these conditions in there. And then sometimes they'll go and do a transaction and forget, oh shoot, I should have gone to the lender and gotten their approval because they have the right to approve this transaction. Anyway, so that's a good example. And the more important agreements, you can even create a very short cheat sheet or an outline of saying, okay, if we're going to do X, Y, and Z, we need their approval, and we need to provide a notice and get these sort of approvals in place. It makes it a lot easier also as you're organizing your documents. Create a data room. Use a very safe and trusted data room. Obviously, if you're using one that's out there commercially available, check to make sure it's got the appropriate data protections and things like that. But essentially, you can create a data room and put all your documents up there, organize them in a way that is easy to understand the organizational structure. And the best case scenario, what we do is when we set up a data room, we set it up in a way where we know as investors are looking at it, they're looking for these categories. So this folder will have capitalization, this folder will have issues related to stock purchases or financings and things of that nature. So it makes it much easier, more efficient, and less time the attorneys have to spend going through stuff, which means less dollars that you have to pay for legal fees. Okay, so next slide, please. I'll give you one other example, I think, and then we can talk about some common pitfalls. So good corporate hygiene, having the right documents. Here was an example of, and this happened more than once actually, where a company has hired someone to come in and help develop technology. Founders have a great idea. They've really thought about it. They know there's a need in the market, but their coding skills or software skills are good, but they're only good up to a certain point, and they really need to bring someone in that's a really good coder to develop the rest of the technology. Or to develop it from the very beginning. So they bring someone in, the person writes really good code, does the engineering for the software. Now they've got a software program that works. They can go out to the market and commercialize it, et cetera. But they forgot to get a really important document signed by that software engineer. And that document was what we typically call a confidentiality agreement with an invention assignment component, which essentially means, or even a consulting agreement that has this provision built in, but it means that whatever they're doing for the company is for the company, paid for the company, is owned by the company. That's the most critical piece there, is that they're developing this for the company and the company owns all the rights to it. So in this particular example, as in others I've seen, they didn't get that document signed. There was no document signed. They paid the guy, or they gave him stock, whatever the arrangement was. He or she wrote the code. After 3 or 4 or 5 months or 6 months, they walked away. Their little piece of it was done. Let's say they decided not to stay with the company. They took a position with another company and basically left. Company's all excited. They've got this great program now. They start to go out and get investment dollars. And in diligence, one of the questions the investor asks is, great, show me these agreements, these confidential information, invention assignment, or proprietary information, invention assignment agreements, because I want to see that everyone that's contributed to anything that has value for the company, any of the IP technology, has signed one of these, so we know the company owns what it's saying it owns and it's created. And they can't find it because they never got one. So the problem there is the person that designed and wrote the code owns it. If you write it, you automatically have some ownership. You've got copyrights to that code that you wrote, and you own it. If you didn't sign it over, it's still yours. So now you got a company that their most valuable asset is owned by somebody else that's no longer with the company. And really what happens is you got to go back to that person and get them to sign the agreement. But if you were that person and the company is poised to go get investment dollars and to scale and grow and hopefully will be successful, you're thinking, well, great, you only paid me, I don't know, 50 grand to code it at the time. I think it's worth a hell of a lot more now. Yeah, I'm not going to sign this agreement until you pay me a lot more. So you end up having very little leverage to get their signature and being in a potential bind where they might never give it, or they're going to ask for something astronomical and you got to spend money to try to negotiate some sort of deal with them. So anyway, takeaway is make sure those kind of agreements you get. You really need a good attorney to make sure you identify what it is you need to get, have the proper language, and get it in place. Next slide, please. Well, okay, so I kind of already talked about this. Is the resolution was they had to go settle with the person and get it back, and it cost them a pretty penny. So the other thing I'll say is oftentimes consultants will come to you with their own version of their agreement. Make sure you read the fine print, make sure you read the agreement, but also make sure you get legal advice, because oftentimes in those agreements, there will be provisions that you do not want to sign, because they might even have provision that says, look, I'm going to come and build this for you, but I own it. And then you've got a problem because you've already signed the agreement. They technically own it. So now you're stuck working with them until you either recreate something from scratch or you amend the agreement and somehow convince them to give it to you. I had that scenario came up. There was a company that was a web-based company that relied heavily on their website. They had a consultant that came in and created the website for them. They didn't get good legal advice. They kind of read the agreement themselves. They missed the part of the agreement that said, oh, and by the way, whatever I'm creating for you is mine. I own it. And, I can take it down whenever I want if you refuse to continue to pay me. Since I own it, I can basically shut your access off to it. Big problem, because that was their business. So anyway, state laws do differ. The other thing I'll tell you is another big mistake I see is people will think, okay, how hard can this be? It's a 3-page document, 4-page document. I'm just going to go pull something off of Google, or I'm going to go to some other website. Or I worked on another company years ago with a similar agreement. I'm just going to pull that and use it. The downside of that is laws change from time to time. So you may be using an agreement that's outdated, that is not compliant with the law. You may be using an agreement from another state where the laws are very, very different and could land you in a big problem if you then have a scenario where you need to try to enforce that. You go to enforce it, and when you go to your attorney to try to enforce it, they read it and say, well, wait a minute, this doesn't work in California. This is totally unenforceable. Good example is non-competes. So I've seen this happen. Company goes, pulls down non-compete from another state where non-competes are okay and valid and enforceable, and says, well, yeah, I got a California company now, my startup, I'll just use this for my employees until they get it signed. California, that does not fly. You cannot enforce a non-compete against an employee in California. There's very, very limited exceptions, and you really need an attorney to walk you through that. It's a dicey issue, because now you've gotten something signed. It may potentially be totally enforceable. They walk away, they go set up, competing business across the street, and you're out of luck. So be very, very careful in doing that. I actually don't do that. Just go talk to the attorney and get it done right the first way. Next slide, please. Okay, I'm going to go through this kind of quickly, and then we'll open it up. We're just about at the hour, so we'll reserve time for questions. Preparing for your first deal, I know I mentioned earlier on in the presentation that I'm really going to be talking primarily about sort of your first financing deal, but it really applies to a lot of other deals, whether it's a customer agreement, vendor agreement, et cetera. But prepare before you start preparing. So I always tell founders and entrepreneurs, if you think you're going to go out and raise financing, before you ever even get to the point where you say, okay, well, it's Monday, I'm going to start calling investors, I'm going to see who I know in my network and set up meetings. Before you can get to that, I would say, a good month or so before that, sit down and work on organizing your company, organizing your documents, creating a data room, doing all the things I talked about earlier. So you're as prepared as you possibly can be before you ever even have that first meeting with your investor, your potential investor. You don't want to wait until you've had a good meeting, they're excited, they give you a term sheet signed, and then you're scrambling because you haven't set up a data room, you don't know where your documents are. That can take hours and hours. And investors want to close deals. They want to make sure that if they're interested in doing a deal, it needs to move quickly. It needs to, at an appropriate pace, but they don't want to deal with delays. So if you're not ready to go, it's going to look bad. It's not a good way to start off a relationship with a potential investor. Anticipate investor questions. So again, do your diligence, do your homework, talk to people that you know, friends in your networks, what have you, that have done deals, that have gone through the process, understand what sort of questions you might get from an investor, and be prepared to answer that. Perfect your pitch, perfect your slide deck, try it out in front of family and friends and others to get feedback, make sure you're comfortable telling the story of your startup. That's important as well. And then use your advisors efficiently. I can't tell you how many times clients, founders will sign a term sheet and then say, okay, now I've got a term sheet. Now let me call my attorney. That's not the right way to do it. Actually, get your attorney involved earlier on, because the term sheet is something that sort of lays the groundwork for what's going to come later with this particular financing. So typically they're non-binding. There may be confidentiality provision or exclusivity provision that is binding, but the rest of it, all the terms you negotiate with the investor, are typically non-binding. But even though it's non-binding, if you then want to change a term later on midway through a deal, that is not at all a good sign for the investor. They're not going to like that. They're either going to push back and say, sorry, it's not in the term sheet, too bad. Or it indicates that, one, you weren't prepared, you didn't know what you were doing, or that you made a commitment, even though it wasn't binding. You kind of shook hands and said, hey, here's the term sheet, and now you're going back on your word. In none of those scenarios does that paint a good picture or impression of you with your investor. So you definitely want to avoid that. Okay, so let's go to the next slide. Yeah, just a few parting thoughts, and I've already covered this a few times. I usually mention this multiple times because I can't overemphasize that, having seen so many of the startup mistakes all relate back to doing your homework, doing your diligence, being prepared. In most of these scenarios, actually probably all of them, could have been avoided if the founders, entrepreneurs had done their homework, really understood what it was, how to do it, gotten good advice, and then implemented, executed based upon that good advice and having done their own homework due diligence. So take the time now, organize your startup, establish good practices for good corporate hygiene, good organization, so that it's already sort of part of your DNA. It's sort of part of your habit on a regular basis. So you don't have to think about it. You just start naturally doing it. And as your company grows and becomes more complicated, with more documents, more people, more assets, more investors, you're already used to doing things in a very organized way. It's going to save you a major headache and a lot of sleepless nights. Okay, next slide, please. Okay, so my contact information is here. Feel free to reach out to me. I know there was, I think, a couple of questions that had some very specific facts in them. I'm happy to talk with you online about those, but don't hesitate if there's anything you need that I can reach out, that I can help you with. Definitely don't hesitate to reach out. So let's open up for questions. I think we have a whole bunch of questions here, so let me see if I can run down. So one of the questions was, what is vesting? So what I talked about earlier was vesting, and the concept really is, it's a way for the company to be able to get back stock that it issued to someone where the relationship with that someone has been terminated, ends. So as an example, you bring in an employee, you give them stock. So stock on day one, they become an owner on day one, and they're going to do X, Y, and Z as an employee of the company. And after, let's say, 3 weeks, you decide, or a month or 2 months, whatever it is, this is not working out. They're not showing up to work. They said they can do all this stuff. They really can't do it. They don't have the experience. We just need to end the relationship. Well, if you've already given them, let's say you gave them, a percent of the company. That's a little high, but leave that aside for now, using round numbers. They're going to walk away with a percent of the company, and they're not going to be contributing. They were only there for 3 months, and yet they're walking away with a percent of the company. That's not going to sit well with investors. It's not good for the founders. So you build into these documents with these employees, advisors, consultants, and founders, as I mentioned, the concept of vesting. So with stock, it basically works where the company has a right to repurchase the stock within a certain period of time if the relationship ends. That's a vesting. When the stock vests, it means the repurchase option the company has to buy it back lapses or expires. So after a certain period of time, they put in their dues, the relationship's good, it's continuing, they've been there for the 4-year period, whatever, then the right to repurchase the stock elapses on all of their stock. So you can't buy it back if they leave. There may be another buyback separate, I won't talk about that, but with regard to the vesting in this scenario, that's how it works. With options, it works a little different because you grant someone an option today, it's a right to buy stock in the future at a predetermined price, the exercise price. So if you give someone, same example, you give an employee 1% in options, and after 3 or 4 or 5 months, they end up leaving, then the options don't vest because they haven't put in the requisite time period for the options to vest. So they basically disappear. They don't have the right then to exercise those options anymore because they disappear. So it works, concept's the same, it works a little differently between restricted stock and options, but that's what the whole vesting concept is. Another question that came in: if an advisor did not contribute as indicated while he had signed a stock subscription agreement, which per time period has the stock yet did not fully fulfill the advisor responsibility, what's the best way to resolve? Okay, so if I'm understanding the question, so if you don't have the right documentation in place, as I just mentioned, you don't have the ability to buy back the stock at the same price they paid for, which is typically pretty minimal early on, then you're kind of stuck. If you've got no way to buy it back from them, there's no contractual requirement for them to sell it back to you or the company to buy it back, then you basically need to go out to them and negotiate the buyback. I mean, you don't have to, but depending on how much they have and what the scenario is, you may want to buy that back from them, but then it's going to be subject to negotiation on what they're willing to sell and what the company can pay. And should the company pay now? If it's a really small percentage, maybe not. If it's a larger percentage, it may be more important to get that stock back. A good question in the chat, and then I'll move over to the questions in the Q&A section. When is the right time for a new startup to hire an attorney? I'm a little biased, of course, being an attorney, but I always say earlier the better. So I understand and work with startups all the time, so I understand budgeting is an issue. But establish a relationship with a lawyer early on so you can get good legal advice. Talk to your lawyer. A lot of lawyers that work with startups, they understand the startup ecosystem. They understand the budget constraints that startups have, and oftentimes we'll work with the startup. Maybe it's some sort of reduced or some discount on their fees. Maybe it's some deferral period. That's on a case-by-case basis. I know a lot of firms don't offer that to everyone, but regardless, and if you can put some money aside, save enough to at least buy a couple of hours. If it's a question that can be answered or something can be done in a minimal amount of time, get that advice early on so that you don't make a mistake. Because I can tell you over and over and over again from experience, cleaning up the mistake is going to be a hell of a lot more expensive than paying a little bit earlier up front and getting it done properly. Okay, so some questions that have come up here. How governments, state, and municipal authorities can in practice support startups avoiding big mistakes? That's a good question. I'm not quite sure I understand. There are some organizations out there that are either government funded or actually part of the government that provide, sort of advice and helpful services. I'm trying to think of the name of one offhand and it escapes me, but there are some out there that where you can go and actually talk to somebody that probably won't be a lawyer. They'll probably be someone who's been an advisor to companies before, and they want to volunteer and give back to the community. So they oftentimes are older, more experienced, so they've been through having worked with companies and will sit down and speak to you and help you out a little bit. There are government grants you might be able to apply for. Sometimes that comes with some help and some guidance, sometimes it doesn't. But I don't know that they're going to be a good avenue. I think the best avenue is educate yourself as much as you can. A lot of great articles out there, there's a lot of great videos, there's presentations like this, and then find an attorney that you gel with, that you've got some good chemistry with. Interview a few, but talk to somebody and then try to establish a relationship. The other avenue is if you've got a network with people that have been in the ecosystem, have built companies, sold companies, invested in companies, run companies, they can be a really good resource to you too. Chances are they've seen or maybe even made the mistake that some of the mistakes I've talked about, and they've lived through it. So they're a really good resource for, oh yeah, this happened to me. Hey, here's what you can do to avoid that. So that's what I would say to that question. I'm not sure there's a really good government agency, but there are also trade organizations that can be very helpful too. So I would also look to see if there's any particular trade organizations that can be helpful. Okay, let me see what other questions we have. Testing we talked about. Yeah, recording will be made available, so probably a couple of days afterwards, you'll all get a link to it. Okay, well, let's see. Okay, so let me see if I'm missing any questions here. We've got plenty of time for Q&A if there's more questions. But I think I've answered all of them. But if you do have questions, please let me know. It looks like we got a few more here. Okay. Is it so in special courses and according to you, special courses and professional preparations can support avoiding startup mistakes? If I understood the question, yes, there are classes you can take. I mean, there's webinars like this one. There's other programs. There are some of the universities offers some continuing education programs or even some special certification programs. I know there are a couple of universities here in the US. I think Stanford has a program, Berkeley maybe has a program that is geared towards sort of financing, like venture capital type financing, where you can take the course and throughout the course, you'll get good instruction on some of the issues that we're talking about now. So there are classes at academic institutions, there are webinars, there are articles, there are lots of other resources. So there's a lot of resources out there that you can go to. What I would tell you though is, make sure that you understand who it is that is giving the advice. If you go, my typical approach is that I'm trying to research something. I want to make sure I'm getting information from very credible, reliable, reputable sources. So, for example, if you find a class at Stanford or Berkeley or another well-known institution, obviously there's a lot of credibility that comes with the institution. So that's going to be a solid source for good information. If you know that, for example, the webinar is being put on by an attorney that's been practicing in that area for quite a few years, they're at a very reputable firm, that's another good indication. If there's a publication that has been very well respected, has been around for a long time, that has good material, then that's another good source as well. So looking at where the information is coming from and then understanding, okay, it's a reliable source, that's a good way to make sure you're getting good information. And if you're seeing the same thing or you're hearing the same sorts of things from multiple points, so you take a course, run across an issue, you listen to a webinar, read a couple of articles, and you're getting the same input, that's a good indication that that's probably a pretty solid input because you're hearing it from multiple sources. Okay, let me see if there are any questions. Let's see. As a founder, should I have a personal attorney as well as my startup attorney if my attorney is representing my company who is looking out for my interests? So that's a really good question. Not one that I get that often, but it's a very important one. You're right. I mean, so attorneys have very, very high duties fiduciary duties they owe to their clients. So they have to do right. They have to be thinking about the best interests of their clients. They have to zealously advocate for their client. And so it's really important if you hire an attorney to understand, okay, who is the attorney actually representing? I mean, typically, so in the case where I'm working with a lot of startups, we're representing the actual company, the corporation itself. Now, if you're one founder, you own 100% of the company, then whatever we're doing for the company is going to translate really for you because you're the only one there. So it's sort of a de facto, we're also looking out for your interests, even though we're representing only the company. It gets a little bit more nuanced or complicated when you have multiple founders. Now you've got a board and you've got investors, because our charge and our prime directive is protecting the company if we represent the company. So what I would say to answer your question is, at the early stage, oftentimes you usually don't need a personal attorney. I mean, if you're the founder and you're creating the company and you're getting the initial stuff going, then there really isn't usually a need for having your own personal attorney. But where that may change is, let's say you get into a dispute with your co-founder, or you have a board seat and there's a couple other board seats and you have a company attorney, and now you've got some sort of tension or some issues about direction of the company because some of the board members want to go one direction and you want to go a different direction, or you're in a situation where the company's grown to a point where you're concerned that maybe you'll be replaced as the director because the investors that are sitting on the board may want to bring in someone with more experience to take it to the next level. And if you're not in agreement with that, then that's a scenario where there might be some tension. There might be some conflict between your interests and the interests of the company. That's a great time for you to make sure you go get someone that's only looking out for your interests. So that's when you want to have a personal attorney, because there may be decisions, maybe things that you need to do, ways to set up moving forward that your personal attorney can advise you, where the company attorney probably won't be able to advise you because they're going to be taking direction from who really controls the company. And that may not be you at some point in time. So really, really good question. Thank you for asking that. Does your office help with setting up company, finding teams, finding financing? Yeah, we do incorporations all the time. We help companies get started. We help with financing. We do the financing rounds. We do have a lot of connections in the ecosystem. So if there's something that we can help you with, certainly reach out. And the one thing I'll tell you is we have a lot of relationships with investors, but those are our trusted relationships. So we are very careful when we go out to make recommendations or to make introductions. We don't just, based on our email that someone sends us, so they want an intro, make an introduction. We need to get to know the person. We oftentimes reserve that for our clients. If we don't know you and haven't worked with you, we're also risking our reputation if we introduce you and that introduction doesn't go well. So keep that in mind. But yes, we do all of that. Okay, so a few more questions. Let's see. Yeah, I think I've covered all the questions. If I haven't, just put it in the chat so it comes up to the top. But we covered a lot of really good ground. I know we've got a few more minutes. I'm happy to sort of close a little bit early if there aren't any more questions, or if anyone wants to go into more detail on a particular topic, happy to do that as well. I will tell you, and I mentioned this a little bit earlier on, I have done a number of these programs. I've done a program on how to prepare for venture capital financing, where I go into a lot more detail on what startups should be thinking about and doing to prepare for their first venture capital financing. So as an example, and sort of a preview, I'll talk about choosing the right corporate entity, choosing the right jurisdiction, what are some initial financing options before you get to your venture capital financing that you can think about and use effectively, and how do those work. Go into a little bit more detail on capitalization and dilution. Go into more detail about how to choose the right investor, how to be thinking about the term sheet and some of the terms you see on the term sheet. So that I cover in a lot more detail, and I think I'll be doing another one of those next month. So stay tuned for that. You can also look, I think either look on my LinkedIn profile or reach out to me separately. I should be able to find the link to those and send it to you. But that goes into a lot more detail on the actual financing piece of it. Okay, a couple more questions. Oh, how to avoid incubators that stole my startup ideas. Okay, well, so I'll talk generally about incubators and accelerators. They have a place to play and a part to play in the ecosystem. They've become very popular. They've been around for quite a while. So essentially what they are is they're usually an organization that is set up to help startups get going. So they help incubate. If you think of the concept of an incubator, you've got eggs they need to be incubated. They need to be heated at the right temperature. They need to be cared for, protected until they get to the point where they can actually become a chick and then, grow into a chicken. So they need that support. They need that incubation. So they will oftentimes put together workshops, programs, presentations, get introductions to investors and advisors, give you all of those tools and resources to help incubate you, to get you all the information, resources, tools to help guide you along this startup venture. Same thing with accelerators. They do very much, they play a very similar role. they help accelerate. So, for example, they will do, webinars, programs, introductions. They oftentimes bring their own people in to speak to the cohorts or the participants in the program. You usually have to apply to the program. You usually have to get accepted. Some of the well-known incubators and accelerators have tons and tons of applications, so they get very, very picky. They're really looking for and vetting the companies that they think will be successful, because oftentimes the incubators and the accelerators, they may be a funding source too. They may provide some very initial early stage seed financing, but they also may end up getting an interest in the company. So if they put in very early seed money, they usually get an interest for that, equity for that. And so they've got a vested interest in making sure they pick the right companies that they think will be successful. Obviously it depends on who you work with. The very reputable ones, I haven't heard of them stealing ideas and really doing disservice to the companies they work with, because they have a reputation. So as an example, some of the top schools, I know, for example, Berkeley here in the Bay Area has a number of those type of accelerator incubator programs. I was involved with one for a number of years as an advisor, where we would come in and as an attorney advise some of the participants in the program, some of the legal issues, and would go to some of the demo days and some of the events that the program had, and it was very successful. They did a lot of good. They brought in a lot of great advisors and people to talk to them. They put on a ton of workshops, legal, financial, accounting, investor workshops, and made a lot of intros. So they can be really helpful, but again, like anything else, do your homework. If you're thinking about an incubator, accelerator, understand what are the requirements, what are the obligations, and check out the references, make sure it's reputable, well-known, been around for a while before you sign up to be a part of any sort of incubator or accelerator. The other thing I'll say is obviously make sure you've got good documentation. So the one thing I didn't cover, I'll cover really quickly, is when you go out to talk to investors, if you're going out to a sophisticated investor, typically some cases angels, but definitely VCs, they're oftentimes not going to sign any sort of NDA or confidentiality. They interact with too many people. They get sent too many business plans and slide decks. If they signed a confidentiality agreement in every one of those scenarios, there'd be thousands and thousands of them they'd have to sign. And to try to manage that process is going to be unwieldy and just wouldn't allow them to do what they do. So again, doing your research, understanding the investor, understanding the reputation in the industry and ecosystem. The good investors, the good VCs, they're not going to want to ruin their reputation by stealing someone's idea, because as soon as they do that one time, their reputation is going to take a huge hit, and people are going to be less likely to want to go and invest with or get their investment and be a part of their portfolio company. So I won't say it doesn't happen, but it's far and few between. And I think that the very reputable VCs and investors, you're not going to see that kind of scenario. But again, do your homework and make sure you know who it is you're talking to, what the reputation is, what the background is, experience, etc. Okay, well, I think we've covered all the questions that were raised. If there are any questions that you didn't get a chance to ask, or if there's something else you want to talk about, my contact information up on the screen. Feel free to reach out to me. Always happy to chat with folks. I love being involved with startups and working with founders and entrepreneurs and investors and their advisors. So if there's anything that I or my firm can do, happy to do so. Even if it's something that's outside of my practice area, like IP, I oftentimes get IP questions. I work with a lot of my colleagues within the firm, and if need be, if you need help, we can certainly get you help on a number of different areas besides just the corporate stuff. So if you are a founder or entrepreneur, I wish you all the well, wish you well, all the luck in the world. It's a great adventure. If you've done it before, if you haven't, it can be a roller coaster ride, but the people I've spoken to that have stuck with it and had a successful outcome say it definitely was worth the ride, because for the lows, there are definitely the highs, and it's great to be part of a solution that you're creating for people and industries and communities, and great to be a small part of that. So I will give you back a few minutes, and really enjoyed speaking to you today, and thank you for attending the presentation. Have a great rest of your week.